Welcome to Face the Jury, a podcast dedicated to confronting the issues of medical malpractice in America, what it is, how to spot it, and how to protect you and your family from medical negligence. I'm your host, Lloyd Bell, a medical malpractice trial lawyer representing people who have been harmed by medical negligence. For more information, visit belllawfirm.com. This episode of Face the Jury is brought to you by our friends at Forge Consulting, the settlement planning experts. Visit Forge at forgeconsulting.com. Today we have a special guest, my friend Josh Koskoff. Josh is a trial lawyer in Connecticut. His firm has offices all over the state. He comes from a long line of trial lawyers, both his father and his grandfather, who started the firm back in the 30s. He's an incredible human being and just a wonderful trial lawyer. To give you just a few examples of the type of quality work Josh does, first of all, he's known as a fantastic medical malpractice lawyer, but he's also known for taking on what seem to be impossible cases that have a strong moral core to them. For example, Josh represented the 10 families of victims of the 2012 Sandy Hook elementary school shooting in a landmark case against the Remington Arms Company. Remington was the manufacturer of the assault rifle used to carry out the attack. Josh also represented Sandy Hook families in a suit against the controversial conspiracy theorist Alex Jones for his false and defamatory claims that the Sandy Hook shooting was a, quote, hoax, close quote, and that it was staged by actors. And perhaps one of the most interesting and poignant cases that Josh and his firm undertook is a case where he sued Harvard University for their continued use and profit from slavery images that one Connecticut woman says belong to her because she has shown that she is a direct descendant of the enslaved people in the famous Harvard-held photographs. The firm is called Koskoff, and Beater. Did I get that right, Josh?
You got it.
Okay. And there are all the Koskoffs in there because Josh comes from a long line of trial lawyers, beginning with his father, Ted Koskoff, who is one of 7 children of immigrants who settled in America, and just the perfect immigrant story. Worked hard, smart as a whip, started his own law firm, built it, brought along his son, Josh's father, who your father ran the firm for, how many years, Josh? Was your
probably about 35 years after my grandfather died.
Yeah, and your dad was Michael Koskoff, who passed away recently, and I never had the pleasure of getting to know him, but I did have the pleasure of reading the books he's written, including his leading book on trying medical malpractice cases, which is just wonderful. So I always regret not meeting your dad, but I've heard a lot of wonderful stories about him and seen him through video CLEs, and then of course Michael, your dad, picked up the baton from your grandfather, ran the firm for many years, and then a number of years or several years ago, when your father passed, you took over the helm, if I can mix my metaphors, and now you are leading the ship of Koskoff, and Beater, and it's just great to have you. So welcome, Josh. Thanks for being here with us.
Well, thank you, Lloyd. That's a wonderful introduction, and it always brings a smile to my face when I hear people reference my dad and my grandfather, who were great heroes of mine.
Well, it's great to have you here, and I think I should let the audience know how we met. I met you a few years ago when we had the privilege of being invited into the inner circle of advocates, a very wonderful group of trial lawyers from around the country that consult and work to try to figure out ways to represent clients more effectively. And I met you in Ireland at our first meeting.
That's right.
And
I don't remember much about that meeting.
Well, I remember you at the bar most of the meeting.
I think I was, yeah.
But during a few moments of lucidity, we got a chance to know each other, and you were working on a case in which you told me you were suing Harvard University, yeah. and I want you to share that story just so the jury, excuse me, I'm a creature of habit, just so our audience can get an appreciation for the types of
Oh,
cases you guys take and the work you do. So tell us about Renty's case.
Yeah, I'd probably be lying if I said this was our regular garden variety case that we handle, but Harvard, it's a fascinating case where Harvard had elevated this scientist in the middle 1800s to lead its department of science, a man named Louis Agassiz. And Agassiz was as famous in his day as Charles Darwin, although I would hazard to guess that few, if any, of the audience that's listening to this podcast had heard of Agassiz, although I'm sure they've all heard of Darwin. And Agassiz, Harvard knew or should have known that Agassiz was just a world-class racist. I mean, just one of the most horrific, disgraceful theorists on race that's ever lived, probably. No exaggeration. And what made Agassiz dangerous was that he was considered a brilliant scientist. He was from Switzerland, and he came to America in around the mid 1800s and was exposed to his first black person, and glommed on to the theory of polygenism, which is a theory that holds that blacks and whites are descended from different species and the whites are superior. And so what Harvard did was said, let's make this guy the head of our department of science, because Harvard was the recipient of a lot of grift from cotton tycoons who built their fortunes off the backs of slavery. The head of the industrial part of the cotton trade was in Lowell, Massachusetts, and those were largely Harvard men. So they wanted somebody in a seat of power that could influence policy after what was going to be the inevitable end of slavery, so that they could ensure slave-like wages going forward after slavery ended. So they sort of planted Agassiz, and that was good with Harvard because Harvard got a lot of money for it. And Agassiz, to quote unquote prove his theory of, or I should put his quote scientific theory that blacks were inferior and whites were superior and from different species, decided that the sine qua non of a study like that would be photographs of enslaved people, and from which he could point to the different features of African human beings and say that they were indicia of a subordinate species. So he went down to Columbia, South Carolina, and he worked with some a plantation down there, a plantation of a guy named B.F. Taylor, and he sort of curated and hand-selected these enslaved human beings for what was going to be his scientific study, proving once and for all that blacks were inferior. And two of those individuals, those enslaved people, were Renty, who was probably a 50 or so year old man who had been brought over from the Congo, or what is now called the Congo, on a slave ship, stolen from freedom and brought to servitude, which is sort of the opposite of the way most people come to this country. And his daughter, Delia, who was probably born in America. And Agassiz's men took Renty and Delia into a studio, stripped them, forced them into poses. Back then, images were taken over the course of minutes, not certainly seconds or milliseconds as they are today. Humiliated in front of each other by being disrobed and forced through no choice of their own to be part of a study from which Agassiz was going to, quote, scientifically establish that they were inferior. Those daguerreotypes, if your audience is interested in the story, and despite my very long-winded and probably not very interesting way of telling it,
very interesting.
Those daguerreotypes, you can look, if you Google Renty photograph or Renty, or just Renty, R-E-N-T-Y, you will see an image that you may already be familiar with and not realize that those are the images that I'm talking about. But in any event, those images have been around and used now for over a century more or less. What really happened was they disappeared for a time. There's lots of intricacies in this, but the long story short is that they ended up in Harvard's possession, and the descendant, the great granddaughter, I may be plus or minus one great there,
right?
Lives in Connecticut. And she's also she's a recently retired probation officer, and she is also was interested in her lineage, as many of us are, and as in particular those who are descendants of enslaved folks for whom this is a real challenge, as everybody knows, that if you were enslaved, you had no, obviously, ability to pass on property or engage in any probating of your estate, or even be provided with birth certificates and documents. And the destruction of the family was one of slavery's most enduring legacies. And it was extremely successful in a bad way. And so doing this tracing your lineage is very difficult. And she managed to trace her lineage back to Renty and his daughter Delia. And when she did that, she was engaged in this process before she even knew there were these famous images that Harvard was holding on to. And when she approached Harvard, let's just say they weren't exactly excited about breaking bread with this descendant and getting to the bottom of it, let alone returning the images to the family. And although she gave Harvard every opportunity you could imagine and then some, at the end of the day, Harvard refused to return them to the family and refuses to really tell the story of the origins of these images. And, it is an eye-opening case because, up here in the North, we get a particular worldview of history that is very Northo-centric, or that
we
really
have something similar in the South, as you may know.
Yeah, I think the Civil War in the South is called the War of Northern Aggression. If I'm not mistaken,
it used to be more, but not as much. Thank goodness.
Well, that's good to hear. But to be serious, I mean, we have a view in the North of the North being on the good guys, and the South being the quote unquote bad guys, and it's so the truth is so much messier. With this, I mean, and what I'm learning, Lloyd, is that you hear a lot about people talking about unconscious bias that sort of is in the bloodstream of our institutions and in our educational system, and that's a term that might make some sort of academic sense to some people, but I don't think until this case did I fully appreciate how deep and how tenacious that bias is. To this day, I mean, one of the things that Harvard did in defending this case, they published their own book. And during this case, and they used, again, the images of Renty and Delia. By the way, we don't know if Delia was even of the age of majority, although her images show her bare-breasted, disrobed, in what would today be considered child pornography. And Harvard freely publishes these under the guise of education. And particularly they're trying to say, we're bringing to light the rigors of slavery. Aren't we wonderful people?
The irony to me is that by exploiting these images of real people taken against their will, taken against their humanity, Harvard kind of perpetuated a little bit of the attitude of the 19th century and earlier. This episode of Face the Jury is brought to you by Forge Consulting. For nearly 20 years, Forge has helped victims of personal injury manage their settlements. Forge Consulting has been a big help in my legal practice. I've been working with them for, probably 10 years now, and they are always available to answer questions. They help when I have liens that need to be resolved before I can finalize a client settlement. They have been fantastic to work with in giving advice to my clients on how to handle their money. And most importantly, they're just good people. I've worked with Corey Phillips for many years, and he is always available to answer any questions I may have, from structured settlements to managed funds and other investment vehicles, Forge Consulting has the expertise and the knowledge to help make the money last a lifetime. To learn more about how Forge Consulting can help you, visit forgeconsulting.com. We were at the top of the Guinness, I believe it was the Guinness brewery at a reception, and we had just met. And I asked the open-ended question. I said, well, Josh, I could tell me what kind of work you do. And you're like, well, I typically do medical malpractice, but I've got an interesting case. And that's how I learned.
3 hours later,
3 hours later,
were trying to hold your eyes open.
No, not at all. It's a fascinating case because, of course, I think what I actually said to you was, well, don't you have something of a statute of limitations problem? I mean, case is more than 100 years old, you typically can't bring. So tell our audience what you did with that challenge.
Well, that's funny that you asked that question because this case would never have happened but for my father when he and he only got the case because Benjamin Crump, who many of your audience may have heard of as a leading civil rights lawyer who's involved in seemingly all of the police shooting and misconduct cases that we've been exposed to so sadly recently. Benjamin Crump was an extra in a movie that my father wrote, and actually the descendant Tamara Lanier didn't come to us directly. Initially, she went to Benjamin Crump because she met him at an NAACP conference, and she approached him and she said, "I have this case, and I'm from Connecticut." And he's like, I don't know. And he basically, she's like, do you know anybody crazy enough to take this case? And Ben Crump was like, actually, Mike Koskoff. So my dad brought this case in and he told us the story and did a much better job than I did. He was a fantastic storyteller. But we were riveted by the story. But the first thing I said was, Dad, this is a really incredible story, but is it possible the statute of limitations ran 170 years ago? Which is not a question. As you know, Lloyd, we're asking, did we miss the statute is it coming up in like a week, or did it possibly, is it too late to take this case because it's already a week past? We're not dealing in years or decades or centuries.
Yeah. You're a century too late.
A century too late. It actually works out because the fulcrum or that this case sort of pivots around is the idea of replevin, which is an old property cause of action. And because property is a physical thing that exists, in perpetuity, and property rights change hands over the course of time. Replevin is sort of a little friendlier to laws of, to statutes of limitations. That, and also the fact that it's sort of been accepted that because Renty and Delia had no rights themselves, and this occurred before the passage of the 13th and 14th Amendment, that the case is deemed seen through the standpoint of the descendant. And when did she learn of her descendancy, and has she brought this case within a reasonable time? And that is being disputed by Harvard, which I think is not exactly very sporting of them, since one of their whole arguments is she can't prove it. She can't prove she's related.
I remember after learning about the case, I may have asked you, or you may have just sent it to me, but you sent me a copy of the lawsuit. We call it complaint for damages. And you sent it as a PDF, and it came through, and I can't remember. It may have been 150 or 200 pages. And I was like, good Lord, how are they writing? This thing is huge.
How did you enjoy the first 2 pages that you read?
I thought the entire thing was fantastic. And I got into the facts, and you impressed me in a way that I did not necessarily appreciate, but that the storytelling in the lawsuit, I mean, you set the scene, the descriptions, that we met the family tree, we went through the family tree, we met the family in human terms. And ironically, it's probably the first time ever that Renty and Delilah received the respect that was due to them as human beings, enslaved human beings. And anyway, I was riveted. So it had 2 effects. It got me through page 241, the entire complaint.
I'm impressed.
I couldn't put it down. I shared it with everybody I knew, who has a similar interest. And the third thing it did is it brought home that our complaints are not mere pleading outlines. but they're opportunities to tell compelling, meaningful stories. And we've adopted, because of you, Koskoff, don't let this blow your head up, but because of you, in part, we have adopted a similar approach with all of our lawsuits. And we tell these very detailed stories with pictures of the family. We go through the medicine with pictures and illustrations, and we lay it out so that it tells the compelling story. And you certainly did that in Renty's case and Delilah's case, which was, I found, incredibly powerful. So this is how I met you. You were telling me about this, what seemed like an impossible case, but a compelling case, in a case that brought attention, to an issue, a dark part of our history, which is, of course, history is our present and our future. That's always with us. But and I was super impressed. And then, but you didn't stop there. I thought you would go on and start talking about the more traditional medical malpractice cases, a retained sponge or a wrong site surgery or something along those lines. And you're like, oh yeah, we do those too. But we also sue gun manufacturers, and specifically, and this is what I want to have you talk about in more detail, but you and your firm have taken on the honorable cause of representing the families of the victims of Sandy Hook in Connecticut. And everybody, remembers that horror of all those beautiful children, being murdered by a young person with a military-style AR-15 assault weapon. And you took on the families and have represented them both against the gun manufacturer and, more recently, against the conspiracy theorist Alex Jones. And what I'd like to do first, Josh, is because I know that there was a recent ruling in the Alex Jones case in your favor, which was greeted with unbelievable admiration for the work you've done to get to that point, and the dedication to these families who've suffered not just the loss of their children, but then the added insult and the lack of respect and the monetization of their experience through conspiracy theories. So tell us about Alex Jones' case and how you came to it, and a little bit about the background and the recent victory that you and your firm had.
Well, the Alex Jones case, as you indicated, it had its soil in our representation of the families against Remington, the manufacturer of the Bushmaster AR-15 that was used at Sandy Hook. And it may be hard to think back that long ago to 2012, but although there were people who knew about the Alex Joneses of the world, it wasn't what it was today. And so dealing in the aftermath of the shooting and working with the families, Alex Jones sort of started to grow out of that. And one of the things that something like this event does, it brings out the absolute best in humanity. I mean, you talk about people wanting to help these families and sending money and all of the well wishes and Teddy, all the types of support, even if it were just words, all these expressions of empathy. But it also brings out the worst. Thank God the best vastly outweighs the worst, but it's the worst that can really punch above its weight. And Alex Jones is probably the worst of the worst. And what we were noticing as time went on is that this guy who initially started off, and my thought was, this guy is just going to disappear. There, and to try to take him on is just giving him the attention and enlarging his profile. And I kept waiting for that to happen, and it didn't happen. Finally, it was just time to call this guy to the carpet and to hold him accountable, if for nothing else, just to shut him up.
Well, tell us what he did. What did he did that you found offensive and legally actionable, something you could do something about?
I mean, and much like you said we were in a gun litigation, but actually the Sandy Hook case is the first time I ever got involved in a gun case. I don't know. I had no knowledge about firearms whatsoever, and no knowledge about firearm laws other than your general negligence laws. But in any event, the families, as they were trying to cope with picking up the pieces of their lives, which will never be the same, but at least trying to move forward. A lot of these families have other children, they have jobs, they have responsibilities, and they just trying to put one foot in front of another. They kept being maligned by Alex Jones directly or through his acolytes or followers. So they were getting harassed in the streets. They were getting harassed online. Some were accused of being fraudulent actors, and they would post their names and their photographs. They'd post names of their children, their surviving children, their decedent children, and then other children that are alleged to be their kids who actually died. And primarily, the big ticket item was really that the whole Sandy Hook shooting was not actually something that happened, but that was something that was staged by actors. And this is known to be a big problem for those trying to recover and get through and manage their grief. Unfortunately,
denying their experience, right? I mean,
deny their experience,
their pain, their grief.
And it's just unfathomable to me, and I'm sure to you and to anybody listening, that you could be drafted into something so horrible. One of your kids could get shot in a school and killed in a school shooting, and that's your ticket to being publicly harassed, humiliated, denied.
Josh, we obviously have more to talk about, and it has been so much fun talking with you today and exploring some of these interesting cases you've been working on. We are going to continue this conversation in the next episode, and we look forward to seeing everybody back here on Face the Jury.